Happy Monday. This is U.S. Immigration Attorney Sharifa Tharpe. I am here with an exciting topic, and I know it's going to interest many of you, and that is how to get the work permit based on family relationships. So, when I talk about family relationships, I'm talking about U.S. citizen or legal permanent resident family members. So, the first thing I want to do is distinguish between the work permit, which it is granted while you're in the United States, and then the work visa. The work visa is when you're outside of the United States and you are coming here. Maybe more common than not is based on the sponsorship of an employer, and in some cases you can self petition yourself to be able to come here on a type of employment based or business based visa. However, I'm focusing on the work permit. So if you're here in the US, you want to get a work permit so that you can work legally here in the United States, then you're going to want to hear this. I'm going to be focusing on this topic for the entire week because there are multiple ways to get the work permit. So each day I'm going to focus on different ways that you can obtain a work permit. Now, the work permit is usually issued. One thing I want to clarify here is you don't come here on a visa. You don't come here on say, a visitor's visa, and then just take that single form that says application for employment authorization. It's the I-765 form. You don't just come here, take that form, and say, you know what? I'm going to go ahead and apply for my work permit. And then you go ahead and submit that form, and then voila, it takes care of the problem. You can get your work permit. There's a little more to it than that, and you have to qualify. So the work permit, you can't necessarily just apply. You usually have to qualify through other means, either through a benefit, immigration benefit, or relief. One of the most common ways to qualify is through while you're applying for permanent residence here in the US, you also apply for the work permit. There are other ways as well if you're applying for certain relief. For example, if you've been the victim of a crime, you've been the victim of abuse, say based on trafficking, if you're applying for asylum, these are other ways. But I'm going to focus on those later this week. I want to focus on family, how to get the work permit today based on your relationship with a US citizen or a legal permanent resident relative. Now, this is not every single US citizen or permanent resident relative. There are certain relatives who you can qualify through. Now, I'm talking about applying for adjustment of status through your US citizen or legal permanent resident relative. That's going to include your spouse, your parent, so your US citizen or legal permanent resident spouse, your parent, your son or daughter who's a citizen and they're age 21 and up. Now, if you're here, let's break this into two more categories, and that's if you're here without status. So if you're here, you ended up overstaying your visa, you can still qualify to apply for your green card while being here if you apply through a US citizen or, well, US citizen spouse, a parent if you're under 21 and unmarried, or if you are the son or daughter of a US citizen and you're under 21 and unmarried. Just in case I just repeated that, somehow I felt like I just said that. But if you're the parent of a citizen and that citizen is 21 and up, then you can qualify, right? So it's only certain US citizen relatives, they're called immediate relatives, who can then petition for you to get permanent residence in the US. And you can stay here and get it even though you overstayed your visa. If you cross the border without permission, you weren't paroled, you weren't granted parole, that's like a permission type of permission to stay. If you came through the border, you may have been granted parole, or if they inspected you in some way, maybe you didn't have your papers, but they did inspect you and the officer did let you in. That's another way that you could qualify through the US citizen, spouse, parent, if you're under 21 and unmarried, or through the son or daughter who is a citizen and they're age 21 and up. Now, if you cross the border without permission and you can't show that you were inspected or paroled at the border or at the airport or at some point that you were here, you wouldn't qualify for this. So just keep that in mind. So if you're the immediate relative of a US citizen, which I just listed here, you are able to still qualify for adjustment of status to get your green card. But the good news is while you're waiting for your green card, you can also get your work permit. The work permit right now, it's taking about 3 to 6 months to get the work permit and your social security number. But once you get that, it opens up the door for you to be able to get your driver's license in the state, to be able to conduct certain business that maybe you didn't get to do before, and to be able to show now that you can legally work and be able to present that to an employer who wants to hire you. Now, what if you're not the immediate relative of a US citizen? So that means that you fall outside of that category. Just to summarize again, that category, those who can end up overstaying and still stay here and get the work permit would be the spouse of a citizen, the parent of a citizen, and that citizen is age 21 and up, or the son or daughter of a citizen who is under 21 and unmarried. If you don't fall within that category, then it means that you do have to show that at the time you filed your adjustment of status, you were maintaining your legal status. So, say you were here on a B2 or B1, B1, B2 already, and you went ahead and you filed the petition, then that would be permitted. But there are other requirements here. This is where you have to be very careful because there are other requirements here. If you are the relative of a US citizen or permanent resident outside of the category that I just listed, then you also have to show that your priority date is current. And that I could save a whole live session just for the priority date. But there is a chart that we refer to, and on your application, there's a priority date that's listed. If your priority date falls before the date on the chart, it means your priority date is current. And that means that you are able to then apply for adjustment of status while being here. But you can't overstay. You have to make sure that you apply for this before you end up overstaying. And your priority date has to be current at the time that you apply for adjustment of status. Granted, you meet these conditions, then it means that you are able to also get your work permit and green card here in the US. Now, I'm going to give you an example of people that can qualify this way. If you are the spouse of a permanent resident, for example, and you're here already and you are thinking about staying, you want to stay with your spouse, now is the time because there is no wait list. Right now, the priority date is current. So that means that you are able to apply for the petition and the adjustment of status to get your green card and the work permit at the same time. Others would be children of permanent residents. So if you're under 21 and you're unmarried and you are the son or daughter of a permanent resident and you meet all the criteria, meaning your priority date is current, which right now it is, and you have not overstayed, you are currently maintaining your status or maintaining your status at the time that you apply for the adjustment of status, then you'd be able to move forward and get your work permit while you wait for the green card. Now, the other category would be if you are over, say, you're over 21. So this is one of the most common situations that I see coming before me on a daily basis. And it's, well, I'm over 21 and I overstayed. I have a US citizen parent. Can I qualify? And the for this. And the answer, it would be the simple answer, if your relative is gonna petition for you, would be no. Unfortunately, if you are 21 or over, you're gonna have to be maintaining your status at the time that you apply for this, and you have to have a current priority date. However, say you have been waiting outside of the US for your priority date to become current. And then say you have been visiting the US, you're here in the US right now, and you check the chart and you realize that your priority date is current. More than likely, the petition has already been approved. And so at this point, once your priority date is current, you're now here visiting. So you have your B1, B2, you're visiting your parent. The petition has been approved. It means that you could move forward with adjustment of status and get the work permit and finish out your process here in the US instead of finishing it out in the country, in your country. So that would be a way that if you are not the immediate relative of a US citizen, that you still would be able to stay here and apply for the green card and get the work permit at the same time. So, it depends. It depends. If you overstayed, you have to be the immediate relative of a US citizen to still move forward with the process. But if you are here, you're visiting, you're maintaining your status, your priority date is current, then you can still move forward with adjustment of status. But if you end up overstaying and you're not the immediate relative of a US citizen, then unfortunately you would not this would not work for you. Now, what if you are the immediate relative of a US citizen? That means and I'm going to summarize that again for you. Immediate relative of a US citizen, those are the people that can end up overstaying or be out of status and still qualify to apply for their work permit and green card. They would be the spouse of a citizen, the parent of a citizen who is age, and that citizen is age 21 and up, or the son or daughter of a US citizen who is under 21 and unmarried. If you can't relate to that category in any way, oh, and by the way, this also includes stepchildren. That's so important. I'm going to explain that. But if you're the stepchild under 21 and unmarried of a US citizen, you could qualify. But here's the catch. If your parent married the citizen before you were 18 as a stepchild, good. You're good as gold. You can move forward as the immediate relative of a US citizen. Even if you overstay, you could still qualify through your petitioning US citizen parent. However, if your parent married the citizen after you turned 18, you would not qualify under immigration law as a stepchild. So they would not be able to sponsor you as the immediate stepchild, so immediate relative, a stepchild of a US citizen. But what if at the same time you didn't overstay? What if you cross the border without permission? Then you would not be able to qualify to, even if you're the immediate relative of a US citizen. There's another process that's where you have to apply for forgiveness for the overstay. And all being well, it's granted, you have to finish the interview at the embassy. Some people don't have a choice but to pursue this option. So if you cross the border without permission, or say you are here, you don't qualify to get the work permit and do adjustment of status because you overstayed and you're not the immediate relative of a US citizen. If you're not the immediate relative of a US citizen, then that means that you'll likely have to do the waiver process. So, as you can see, there's a lot of analysis that has to go into determining whether you can or cannot get the work permit and green card here. But one thing I do is when I ask, the first thing I ask is, are you the immediate relative of a US citizen? If you are, then there is a good chance that you'll qualify for that work permit. if you are the spouse or the son or daughter of a permanent resident, then you could qualify if you're here on status now. If not, there are options, but it's not going to be adjustment of status where you can get the work permit. Now, I want to jump though to another type of option here that's based on family relationships that will enable not only immediate relatives of US citizens, but also permanent relatives of permanent residents to be able to get their work permit and stay here in the US and get the green card. Now, this is through VAWA. Now, VAWA is called the Violence Against Women's Act. First thing I want to say, if you've been watching me for a while, you know what I'm going to say. It's not just for women, even though it's the women are the only gender listed in this law, but it covers everybody. So no matter who you are, it covers you as long as you're going through what a situation that qualifies you. Now, if you're being mistreated by a US citizen or legal permanent resident spouse, a parent, if you're under 21 or unmarried, or by a citizen son or daughter who's age 21 and up, then you could qualify to apply on your own. And this covers you even if you cross the border without permission, even if you overstayed your visa, and even if you're here on current status. It covers everybody. What's important here is that you have gone through this kind of mistreatment from this relative. And it covers not only, you don't only have to be the spouse or the immediate relative of a US citizen, but you can be the relative of a permanent resident and qualify for this. If you have a parent who mistreated you, then you usually have to be under 21. However, if it's the mistreatment that also led to your delay in applying, then you have up until 25 to apply for this relief. So the clock is ticking there. Now, stepchildren also qualify for this. Stepchildren of permanent residents and citizens qualify for this. Step parents of citizens qualify for this. So, say you are the step parent of a citizen, and under immigration law, you would have had to, of course, marry the parent of the child before they turned 18. But say you are the step parent of as an adult citizen, and that adult citizen is mistreating you, then you qualify to apply for this. So even if this spouse or the spouse or the parent or the child has died, or they have lost their status if they're a permanent resident, then you have 2 years to apply for this relief. If as long as you can show that the death, the deportation happened less than 2 years ago, then you can apply for this relief. So keep this in mind. And this with this second form of relief, right? So the first category I talked about was where your relative is petitioning for you. They're active in the whole process of sponsoring you for your work permit and green card. However, in this under VAWA, the relative is not going to be included in your process at all. As a matter of fact, this is so confidential that it will never be disclosed outside of the agency. That means that your relative is not going to get into trouble with immigration because the goal isn't to penalize the relative. The goal is to see to it that you get the relief that you deserve, that you're not getting because you're being mistreated by this relative. Now, the relative, keep in mind that this mistreatment, when I talk about mistreatment, it is broadly defined under VAWA. That means that I want you to get the whole idea of domestic violence out of your head. Domestic violence is broadly defined. It's not just a type of mistreatment where it includes physical abuse, but there are other forms of abuse that qualify here, and that qualify as domestic violence or abuse, or extreme cruelty. And under VAWA, you can also show extreme cruelty, not just domestic violence, as in the physical type of domestic violence, but if you're verbally mistreated, emotionally, if your spouse is toxic, if they're a narcissist, and they're using that to manipulate you, control you, if they're threatening to not go forward with the papers, or they're threatening to cancel your papers or not go to the interview, if they've canceled your papers because you didn't do what they said or they were being vindictive, these are examples of extreme cruelty that can qualify you for this form of relief. Now, when you apply for this form of relief right now, both spouses of permanent residents, children of permanent residents, and citizens um, can apply for this relief, and can at this time apply for your work permit and apply for your social security number and your travel document at the same time, and the green card. So while I'm talking about ways to get the work permit is sort of like a means to an end. You get the work permit while you're waiting for your entire permanent resident process to be completed. So the benefit here is it does not end with your work permit. It ends with a green card, all being well, and you're approved. So keep in mind that getting the work permit and the green card based on family relationships does not necessarily mean that your family member has to be the one to petition for you. But if you qualify based on mistreatment by that relative, or abuse, then you can take control of your own process and move forward to apply on your own. This it can qualify you, yes, even if you're currently still in the marriage, still in the relationship, still living with them. While we make sure that our clients are safe while doing it, we want you to prioritize your safety. One thing we do is we make sure that everything is sent to our office, to this office, so that you're not compromised if you have to apply for this while you are still in the same household. But sometimes I find that it is necessary to go ahead and move forward with applying, even if you're still in the same household with the spouse, with the parent, with the adult child, because maybe that is your means to gain independence. Is that's the way that you're going to be able to get the work permit to escape your situation, or to be able to gain independence and leave the situation. So keep that in mind, that because it's so confidential, and because there are measures that we take and that the USCIS takes to make sure that you're not compromised, people are still able to apply even when they share the same household with a relative. So that is, in a nutshell, how you get the work permit based on family relationships. I know I just gave you a 101, immigration 101, on how to get the work permit, and I just want to be very clear with you, because whenever I ask on my post, do you want to get the work permit? Do you want to get the green card? The number one question I get is how. So I have opened up my door to show you how we do this based on family relationships. And it's also based on different scenarios, different situations, circumstances of our clients. But this is one way. Remember, for the rest of the week, I'll be talking about the other ways. This is one way. If we're going to summarize it all based on family relationships, that this is a possibility for those who are here without status, may have overstayed their visa, may have crossed the border without permission. There is still a solution. And what I would say now is, don't overthink it. Let me do the work, and let me help you to get to that point where you can get the work permit to legally work here and then end up with the green card. go ahead, call the number on the screen on YouTube, on Facebook, and Twitch. And on Instagram, go to the link in the profile, and it's going to take you to a website, Linktree, where you'll see all the links to be able to schedule your own appointment. It's really easy. Or call the office or go to the website if you want to learn more before scheduling your appointment. But it's very easy to get in touch with the office to be able to schedule your appointment and get started right away. Now I'm opening up the floor for questions. So go ahead, put your questions in the comments, and I will answer your questions. Thanks so much for tuning in and listening. And I hope you join me for the rest of the week, because I will delve into some detail about how to get the work permit, other ways to get the work permit. So say you don't have a family relationship, or you don't have a qualifying family relationship. How can you get the work permit? I'm going to talk about those for the rest of the week. Bear with me. I'm just going through and finding questions. Hi there, Cheryl. Hi, Caroline. Always nice to see you. Thanks for joining on YouTube. All right, now is the time to put those questions in the comments. If you have questions, follow-up questions, general questions, any immigration-related questions, now is the time to put those questions in the comments. Can a permanent resident file for their parents? No. So the permanent resident has to first become a citizen before they can file for the parents, and they have to be a citizen who is age 21 and up. It's always great stopping by. I always learn a lot. Thanks so much, Vicente. I appreciate you taking that time. What kind of documents would you require from a partner to file VOA? So great question. Now, what you need here is you need to remember what you went through. The number one most important piece of evidence is going to be your statement. Now, this is not just a statement that says, "Hi, my name is, Julie, and I was abused by my spouse." It has to have enough detail for the officer to accept this as credible evidence. And keep in mind that if you have very little evidence, which is very common, surprisingly, is very common, is that a lot of people don't have evidence. You're not while you're being mistreated, you're not necessarily taping yourself. Sometimes it's done in private. Sometimes the spouse or relative or parent, in this case you said a partner, the partner will do things to cover up their mistreatment. So, any credible evidence is acceptable evidence. And that means if it comes down to your statement, which it has to be sufficiently detailed to be accepted, then that can also, that can be a very valuable piece of document to show that you qualify for VAWA. But, of course, there are other documents. Now, when you're dealing with VAWA, this is where you're applying based on mistreatment by a spouse, by a parent, or an adult child. You have to show not just the mistreatment, but you have to show that you do have a real qualifying relationship. So that means, if it's a marriage, the marriage certificate. If it's the parent child, the birth certificate. Then you have to, when it comes on to the marriage, same as an actual marriage-based green card process, with VAWA, you do still have to show that the marriage was bona fide and you entered it in good faith. So I would say that this is treated differently, just because sometimes the abusive partner, or the partner who is mistreating or subjecting the immigrant spouse to extreme cruelty, they don't want to be able to give the immigrant spouse any kind of control. So they don't have access to the bills. They don't have a shared account. They don't have a shared, insurance. They're not on the health insurance. They're not on the house. They're not on the lease, right? This is very common in these types of relationship where there's an imbalance in the power in the relationship. And when I say with that, we brainstorm with our clients to determine what's the best evidence to use in their circumstances, because some of them do have some evidence. Some of them they may not have the usual traditional evidence, and so we plan all this is the reason that representation is essential, because as an experienced attorney, I can come up with solutions here as to how to present credible evidence of the good faith marriage. So that's, the kind of document is going to depend on the circumstances, but you have to present. The most important one is going to be your statement. Go ahead, drop your questions while I'm here. I'm going to be here for a little bit, a little longer. So go ahead, put your questions in the comments. How long does it take to get work permit after biometrics? So I don't usually count from the biometrics because the biometrics is all over the place. You might get one 2 weeks after you apply. You might get one 3 months after. But what you should be looking out is if it's VAWA, you're looking at up to 12 months, 6 months to 12 months. If it's a marriage base, you're looking at about 3 to 6 months. Or the family base, it's going to be 3 to 6 months. How long after I do my biometrics for VAWA will I get my work and travel permit, and how safe is it to travel on my work permit? So you're looking at about 6 to 12 months to get the work permit and the travel document. Is it safe? Many of my clients travel only. I really advise on a case by case basis. So I wouldn't be able to tell you how safe it is for you to travel. However, in cases where my clients present a very low risk, their background has, that their background doesn't have much in there to find any complications, then it's very safe. My clients do travel. The ones that can, they travel, they go on vacation where they can. Of course, keep in mind that if you have that travel document and you are going on vacation, make sure you have a visa, because the travel document doesn't, it's not like a visa to go to other countries. You still have to be able to, make sure you qualify to enter any other countries you go through. But my clients do travel, and they not only travel for required reasons or urgent reasons, but sometimes for vacation. What documents are required from the spouse if you file for VAWA? Great question. Nothing. So the spouse has no say in this, because this is all about you. So you, as the person applying for VAWA, you're in control. You're the one that will be filing, signing everything. There's nothing that is going to be requested of the spouse, because they want to protect your interests while you're applying for this form of relief. Um, So is the declaration of status, hi there, Natalie. Is the declaration of status at the hospital even legal if this intimidation on healthcare should not be a source of fear for anyone? So yes, if there is a question there, and I'm pretty sure that this is going to be challenged. This is going to be challenged in court. However, I think the way that they're getting around the legal issues is that they're requesting that the hospital disclose a report of the number of people with this status or that status, but the hospital is not to submit the individual identifying information. So they can't say they cannot call a name, have a report with your name, your address, your immigration status, your health condition. They are to issue report to the state. Well, 10 people came to the ER with undocumented status. Another 10 were US citizens. So I believe that that's how they're getting around that legal question there. But I'm pretty sure, nevertheless, because of the nature of the law that is meant to intimidate, that this will be challenged. My documents have come through as yet, and my daughter turned back on me and really do need my work permit to get a job to help with my small daughter. How can I get help? Okay, so in this case, it's similar to, so this may be a VAWA issue. If your daughter is sponsoring you and now she has abandoned you in the process, this is where you should definitely schedule a consultation, and let's talk about where you are in the process and whether you're able to apply for yourself. If your daughter has, because the parent child paperwork is different in that you may just get your green card in the mail without an interview. But if she hasn't even filed for you and she's mistreating you, and that's why she's turned her back on you, then you're able to apply for VAWA. So parents are able to apply for VAWA. If you are the parent of a citizen and that citizen is age 21 and up, they're mistreating you, they're doing things to drive you crazy, then you can apply on your own. Now when I say they're doing things to drive you crazy, let's talk about that parent child relationship. It may be a situation where your adult child, maybe in the past, maybe even now, they're 21 now, but maybe they have substance abuse issues. Maybe they're doing things that they shouldn't be doing. And as a result, that kind of behavior is also flowing over onto you, where you're being mistreated, you're being financially exploited or abused yourself. This can be a basis for VAWA. Now, of course, as parents, we think we don't ever want to file any paperwork that will negatively affect our children. However, in this case, what I will say is the goal of this application is not to send law enforcement for your children. It's not to, create a criminal record for your children. It's not to bar them in any way. Plus, they're citizens, so it's not like they'll be deported or face any immigration consequences for what they have been doing. It is to make sure that you, as the parent, get the relief you need moving forward. What if the apartment complex doesn't want to put you on without social? So, that is another legal issue. But yes, I have seen that where they don't want to they don't want to put you on the lease because you don't have a social security number. And now we have this law in Florida that's coming out July 1st that will probably make this worse, because now, living with an undocumented immigrant can mean that you're going to face consequences for that. And so it's another type of issue. But if that's the case, if you're talking about evidence, so my clients have had that issue and we just find other alternate evidence. I don't have any documentation as yet. I'm not married. I'm here in the US from April 13, 2022. What's the best step or direction to go? Do a consultation. I can evaluate your personal circumstances and then determine whether there is a solution. You can also join the live for the rest of the week. If you can rewatch this if you joined later. But this is based on family relationships, not just a spouse relationship. And then you can also watch live throughout the week, because I'm going to be focusing on different ways to be able to get the work permit while you're here, and the other forms of relief like status, special type of statuses, or the green card. So stay tuned or schedule that consultation if you want me to evaluate your personal circumstances, because keep in mind, this is not personalized legal advice. This is general information. If you're here and don't have anyone to petition for you and you're adult, what is the process? So it's again going to come down to your circumstances. So I've had consultations like this, and it turns out that based on my detailed evaluation, I'm able to determine that the client qualifies for other forms of relief. For example, they may have come here without a relative because they were recruited by an unscrupulous employer who then trafficked them. And they could apply for the T status as a result and get their status that way and eventually get their green card. Some of them are afraid to return to their country because they are facing, persecution, being targeted in their country, and that's asylum. So that enables them to stay here. So even if you don't have family members, it's important to do the consultation because you may be able to have other options you never thought about. All right. So good day. I live in Florida and I apply for no be approved. So if you received it 4 times, that's possibly like 2 years or more of waiting. And my question would be: did you apply for the work permit to start with? Because you do have to apply for it through adjustment of status, and so that may be the issue. All right. So that's going to be it for me today. I've run out of time and I see so many questions that I'd love to answer, but I've run out of time. But ask those questions tomorrow because you can ask any immigration related questions that you want to ask. So join me tomorrow where I will address a topic, but you can come with any immigration questions that you would like to come with, and I'll answer those questions as well. All right. Have a good day. Thanks so much for joining. Bye bye.